Under main scenario, we are a practice team of quantity surveyors that was appointed by a private client in Kuching, Sarawak. The memorandum of agreement requires QS to provide services to the client based on the preparation of interim certificate. Majority of the construction contract involve interim payments as a mechanism for the client to make payments to the contractor before the works are completed. By introducing the method of interim payment, it helps to ensure the progression of work done by the contractor. At the same time, helps to relieve the financial burden of the contractor where a construction project which may take several months to up to years for completion. The process of interim payments involves a strict procedure where interim valuation and interim certification take place with the contract condition. There will be a set of clauses that intended to organize the procedure of interim payments where under certain contracts. Within the interim payments period, that rules of administration occur which involve quantity surveyors, architects, employers, and contractors.
The contractor must submit a payment application at the interim pay interval stated in the appendix with complete details and particulars to the architect and QS based on the PAM 2018 clause 30.1. If the contractor fails to submit a payment application, it shall be deemed that he has waived his right for the issuance of the interim certificate for the relevant interval. After the contractor submits interim payment application to the architect and QS, the QS ascertains the amount payable to the contractor. If there is no error or discrepancy in the previous certificate reviewed by the QS will recommend the interim valuation to the architect. Those items to be added in the interim valuation are total value of work properly executed, materials on site or materials off site, PC sum, variation and provisional sum, and also claim for loss and expense. Those items to be deducted in the interim valuation are retention sum and set off by the employer as agreed by the contractor. If there is error or discrepancy in the previous certificate reviewed by the QS will correct or modify the previous interim valuation and recommend the changes in the current interim valuation to the architect. Then only proceed with the items to be added and deducted in the interim valuation. Afterwards, the architect will issue an interim certificate to the employer with a copy to the contractor within 21 days from the date of receiving the contractor's payment application.
Upon receiving the interim certificate issued by the architect, the employer is obliged to make the payment according to the amount certified to the contractor within the period of honoring certificate. If none stated, it is 21 days from the date of the certificates, based on clause 30.1. If the employer neglects or fails to make the payment after the period of honoring certificate, the contractor shall give a written notice to the employer via hand or registered post. The written notice shall state that if the employer neglects or fails to pay to the contractor within the 14 days from receiving of the written notice, the contractor can suspend the execution of work until the correct payment is made. After 14 days of sending the first notice, if the contractor still has not received the payment by the employer, he shall send a further notice by hand or by the registered post to notify the suspension of works. On the other hand, if the employer made the payment upon receiving the first notice within 14 days, the contractor shall proceed with the works. So, if the employer are able to make the payment within the period of honoring certificates to the contractor can continue with his work without worry.
There are two approaches of payment to the nominated subcontractor, which is firstly, payment by the contractor, which is included in the clause 27.5 PAM contract 2018. So the payment process by the contractor to the NSC starts after the contractor claimed for the payment. Within 21 days or less, the valuation by QS shall be made. Only then will the architect issue an interim certificate. Therefore, after the PHC, the contract will be paid by the employer. After that, the contractor must make payment to the NSC within 7 days or less. Well, the next approach is the direct payment from the employer, which is included in the clause 27.6. This approach emerged under the circumstance that the contractor failed to provide proof of payment to the NSC. It starts with the architect's request of proof payment from the contractor to NSC. If the contractor failed to do so within the time frame of 14 days, then the architect may issue an interim certificate to pay directly to the NSC. Therefore, within 21 days, a direct payment shall be made to the NSC by the employer.
With the rising COVID-19 cases ensuing the government's implementation of the MCO, there is an emerging issue among the construction industry's personnel and the client relating to the entitlement of an extension of time for the contractors. Both the clauses 23.1 and 23.8 of the PAM document entitle such extension provided that the encountered event was not by default of any contractual parties, where it was beyond their control and is accepted as a force majeure. Firstly, the contractual party must first establish whether their contract is viable to a force majeure. Subsequently, the party must ascertain that such term incorporated in the contract must be wide enough to account for the COVID outbreak. Since the outbreak has been declared as a global pandemic, it is likely to be deemed as a force majeure event, and thus contractors are likely to be entitled for an extension of time for the project. To claim for an extension of time, the contractor will have to give a written notice to the architect. When submitting the notice, the contractor will have to include documents such as an estimation of the time needed and a delay analysis, which is needed to show that the cause behind the need of such an extension was not due to any parties, and in this particular case, the cause would be the commencement of the MCO. After providing such particulars, if the architect finds that the information is lacking, they may request for further information within 28 days of receiving the notice. If there is sufficient information, the architect can proceed with assessing the claim. If approved, the MC and the NSC will be notified of the new completion date. There is, however, a chance that the claim will be rejected, but as discussed before, there is a higher chance of the claim being accepted due to the COVID outbreak.
Although the contractor can claim for extension of time, he is not entitled to a claim for loss and expense due to a force majeure under PAM 2018. The case of COVID-19 and the implementation of MCO is considered as an unforeseen event, and it was not due to any party's fault. Therefore, the associated loss and expenses must be borne by each party. However, the contractor may potentially claim for loss and expenses based on one of the following grounds which are caused by the employer. The first one would be a written architect's instruction to suspend the works. The second one would be failure of the employer to give in due time entry to or exit from the site. The third one would be delay in giving site possession to the contractor during MCO. And the fourth one would be renomination of nominated subcontractors, nominated suppliers, delay on the parts of craftsmen, tradesmen, and other contractors during MCO.
Procedure for the contractor to submit the claim for loss and expense. When the contractor has incurred or is likely to incur loss and expense, he needs to submit a written notice regarding about the claim to the architect, which includes the estimated amount for the claim along with the breakdown of the claim within 28 days upon receiving from the AI and CAI, or the start of the occurrence of the matter which is raised in clause 24.3, whichever is earlier. The written notice is important as it is the condition precedent for the contractor to successfully claim for loss and expense under the contract or common law, clause 24.1a. Within 28 days after the matter referred in clause 24.3 or within longer period which has been agreed by the architect in writing has ended, the contractor needs to send complete details regarding the claim for loss and expense, including calculations to the architect and quantity surveyor. Failure to send the details in the given time frame will waive the contractor's right to claim for the loss and expense. According to Clause 24.2 PAM 2018, the architect and quantity surveyor has the right to request for any documents or details regarding the loss and expense that the contractor intends to claim. The contractor must send a copy of the documents to both architect and quantity surveyor when submitting a claim for loss and expense. The contractor shall use his best endeavors to keep contemporaneous records of his claims for loss and expense and shall submit all particulars to the architect until all claims has been resolved. Procedure for the architect and the quantity surveyor to ascertain the amount of claim. In Clause 24.4 PAM 2018, it is stated that an architect and the quantity surveyor are responsible to make sure the amount that the contractor wants to claim is correct. The amount claimed for loss and expense shall be added to the contract sum as well as any future interim certificates.